Welcome to Rogue's Legal AI Conversations. Today, how to stop hallucinated citations. Ali Mohammed, founder of Jurist AI, explains a simple rule. Never let AI insert any citations. Let's jump into the conversation. So how have you been, man? We didn't talk for a couple of weeks. I'm pretty sure it's been busy. How are things going with Jurist AI?
Yeah, things have been extremely busy, but it's better to be busy than not busy, right? Right now we're working on, so we have that hallucination detection feature that we'd spoken a little bit about, but we had it previously integrated as part of our document flow. So you generate a document on the platform and then it would check the sites and then validate them. So we've isolated it. So now what people can do is, I've written a draft, let's say, and maybe I use ChatGPT or I was sloppy, or maybe I even did my due diligence, but I want to be careful. So users can go and upload it, and then it will review it and check the sites, and then let you know, hey, look, these are good, and this is where we found them, and these we're not so sure about. And then I'll also do like a little brief critique of the document. So we've isolated that. That's what we've been working on, and then we want to put that on a separate page so people don't have to necessarily be part of our users to go, try this isolated feature out. So that's what we've been working on.
Yeah.
So,
What got you into this space? Could you tell us a little bit about the background, how you got there, the journey?
yeah, I grew up in the Washington D.C. area, and when I was growing up, there was a huge focus towards STEM, but I was always more of a humanities person. I was always really good at English classes and history. So I went to college, I did computer science and IT, but while I was there, I did an internship as a paralegal for a criminal justice firm. And I was really good at it. They pleaded with me, hey, you really need to become a lawyer. But, everything was moving towards you have to do IT, you have to do STEM. So that's what I ended up doing. I ended up doing a master's in IT management. But that experience always stuck with me. I've always had a lot of concern about justice and inequality. So when ChatGPT hit the scene 3 years ago or so, I thought, oh wow, this is going to be so great for access to justice. This is going to really revolutionize, um, you know, a lot of the inequities that we see, especially in the American court system. But that didn't really materialize. So about a year, and I figured, you know what? Why don't I throw my hat in the ring? I was a solutions architect. I was a technical engineering manager. I had some funds saved up, so I built the only thing that I knew, which was criminal justice. So I built a primitive litigation lifecycle tool for criminal justice. So that's how we got started.
I want to ask you a little bit because in the previous conversation that we had, we were talking about how we both kind of started from the engineering perspective in the AI when it showed up the first. And we were both talking about chatbots. We were both trying that. I mean, like that was literally the thing, right? That was the obvious use case. And how do you see this, the start with experimenting with chatbots, and then the platform that you have built today, which is pretty much workflow based?
Yeah. I think chatbot is, the obvious first step because that's how it's presented. But if we take a step back, a chatbot is really just an interface for an LLM, which is a text generation engine. So there's no reason to conceptualize of an LLM in that chatbot format. It's just designed to produce text based off of inputs and context and token prediction. So when we started to see some of the pretty obvious gaps, like hallucinations or forgetting context, I think it became clear to a lot of people that maybe, chatbot format and relying solely on LLMs is not the best idea. So that was one of the theses that we founded Jurist AI with is that, look, lawyers and even pro se users, they don't need a chatbot to go back and forth with. What they need is really robust, built in legal workflows that use generative AI LLMs for some pieces for it where it makes sense, and areas where it doesn't make sense, not to use it.
So that's how you got to Jurist AI today. So basically, you have a highly controlled system which you identified and broken down into steps because you know how the litigation actually works under the hood, and you are deciding where you're going to use AI or not. And one thing that you mentioned, hallucinations, I want to build on top of that because actually I wanted to take this opportunity today to try to demystify them a little bit. Where are they coming from? There's been also an interesting quick communication I had. I had a LinkedIn post recently about how important it is to build a data foundation. No matter what kind of a system you're going to build on top of it, whether it be a file search or whether it be a autonomous agent, right? You need that foundation, and that foundation needs to be clean and organized. There was somebody, and that I wrote that specifically because there's a lot of we solved that with RAG. It's just a
Mhm.
word that you throw in as a solution, and because you said it, it seems like you solved it because you know the word, right? So then it
Yeah.
must be that it's true. And I had one of those comments on the post, and then I went a little bit deeper into okay, how non-deterministic RAG is by default, and if you think that the AI that is the generation part, that the thing that actually generates text, if you think that that is the problem, is that it's non-deterministic and it hallucinates, imagine throwing in another hugely non-deterministic component. So now you have two non-deterministic components, one
Yeah.
that is non-deterministically fetching your data and the other one that desperately relies on the quality of the data. So how do you really solve the hallucinations there? I mean, like, yes, of course, and you can. This is actually the way to go about this. It's been around for years in recommender systems, way before Gen AI hit the headlines. But you can't really say that you solved it with RAG because RAG is highly dependent on one specific use case. Even two law firms that have similar documents don't have the same RAG. RAG has many different components. There's many different versions and variations of RAG. How are you going to design and architect it? So, how did you, because the way you're handling hallucinations is super simple, very elegant, and very different than trying to
Yeah.
use a complex system to solve a non-deterministic problem. So I wanted to ask you a little bit about how did you, because you were working with RAG before, right? How did you migrate from there and what are the learnings?
We still use embeddings, but not for citations. So when somebody wants to go through case documents, for example, then it can make sense to use embeddings to a certain degree. But like you said, embeddings and then times a generative component, it's non-determinism times another layer of non-determinism. So RAG is not the solution, obviously. The best that it could possibly do is recommend. I saw something really interesting the other day, which was someone did a collection of case law hallucinations that had been filed in court,
Mm.
and what tool led to the hallucinations. And there were some big names, and it's shocking because these are the same big names that will claim that, hey, look, we use RAG to pull out case citations, so it's highly accurate, and we have the best data in the industry, which they certainly do. They definitely have the best data, but what we do is, like you said, it's pretty simple. Every statute, every rule, every case law precedent, at least in the United States, has a very specific format, and you can locate them based off of those formats. They all look the same way. That's how you, as a human, recognize them as being a citation, right? So what we do is, whenever AI tries to put a citation in, we programmatically find it and we just delete it because we don't trust AI to be involved in the citation game at all. Because it's doing a math calculation every time, right? To figure out the next best word, the next best sentence, the next best paragraph. So you're rolling the dice on every next token. And not to make it too nerdy for lawyer viewers, but you're just gambling with something that looks accurate, and that's fine for logic, right? That's fine for abstract things, because when you're dealing with abstractions, there's no um, exact specific facts that you need to go back and reference. But when we're dealing with citations that have to actually be from history, then it becomes more problematic. So what we do then is we have an isolated context that documents are produced in for any one case. So every case that we handle has a single isolated context just for the documents. When we produce a document, and then we go and programmatically remove the citations outside of that context. We then ask it, hey, if you were to try to make this document more robust, what kind of research would you want to do? We get that research, and then we go to a lexical database. We conduct the research on a lexical database. We get actual citations. We get actual opinions. We get actual statutes, rules. We pull all of those. And then now we have a document that has a whole bunch of, hey, you really should have a statute citation here. Hey, you should have a case law citation here. And then we have a whole bunch of rules and statutes and case citations with brief summaries, objective analysis of just, whatever the opinion or the rule is. And then we intelligently reinsert it. So we have a ranking according to relevancy. Hey, this is the most relevant one for this part. This is the most relevant one for this part. But at this point, the AI stopped touching the document when it stopped making legal argumentation. So the AI is not touching the citations, it's not reinserting them, it's not doing anything more now that the legal argumentation is there. So we guide it, we show it, hey, look, this is what this kind of a document should look like. These are the sections, here's the case facts, here's the arguments, and then we figure out, hey, look, these are where citations should be, these are where rules should be, these are even where exhibits should be. And then we have a totally different pipeline that will go in and put them. And then just to make it even easier for the user to verify, we hyperlink everything that is cited. So it's a blue link, you click on it, it takes you right to the federal rules of civil procedure, or it takes you to whatever case that was cited right there so that you can easily go back and check and make sure that it's valid.
I really like this approach. That's actually why I kept on following you. And it's very interesting. In many different posts that I had on LinkedIn, you commented, "Just don't use AI for citations." It's just so true. It's
Yeah.
the other day I had a conversation with Utah-based litigator, and she's using heavily ChatGPT, and she's of an opinion that hallucinations being a problem is the wrong conversation to have. It's just there. We got to accept it and work around it. And you had to double check on everything that your assistant produced or whatever kind of program that you were looking for citations produced. So nothing changed with AI. You still have to double check it. But if you're locking yourself, because hallucinations on one end, I mean, they are pattern recognition and prediction based on pattern recognition, right? Okay, so the way she uses it is that she allows AI to give her arguments, and then she goes and finds the citations because the argument usually nudges her in the right direction, even if it's hallucinated, right? Because it's a pattern-based result. It's hallucination one way or the other. We just kind of call it hallucination to kind of
Yeah.
humanize the AI more. So we think that there's an entity behind AI. It's just a statistical, yeah, net. So yeah, very interesting how you're handling this. And what is it? So I wanted to ask you, like, I don't want to sound too like, that we're trying to promote your product, but I really like how the architecture is being done. So the goal for me is also a little bit because the idea for the audience is to be more lawyers, so non-technical people. So in that sense, how can we present it more to them? Why? Yeah, this is the right approach. So one thing that I got out of one of the conversations with Knut Magnar, so I just recorded a podcast with him as well. So the point was that he was talking about stages that we're going through in this AI wave. And one was using AI for dumb stuff to do our admin stuff for us. The other one where we're kind of headed more towards is using AI to create more friction. This is literally his words. Use AI to create more friction. And in that sense, you are adding more friction in your platform as well, because you are embracing hallucinations, you are embracing vector embeddings in one space where AI kind of does the explanations, reasonings, but not the hard deterministic stuff. How do you see that balance evolving in the future? with your platform and in general in the legal tech space?
Yeah, I think there are the chatbot for every circumstance approach just misunderstands how lawyers work. And you have to ask yourself what you're setting out to do. Are you setting out to emulate how lawyers work, or are you setting out to solve any one specific small problem, like what your last guest said about dumb work, like admin work, for example? For us, we really want to get to a point where we've built an autonomous legal associate so that you have a genuine coworker that you can work with. And if that's the case, when you go to law school and you are taking courses, there are certain things that are not creative, right? There are certain things that are done in the same way every single time, and you have to follow a very specific, predetermined path for how things work. And then within those steps, there's some creativity, or there's creativity in deciding what steps to choose. Chatbots don't capture that because a chatbot is every time, rolling the dice, essentially guessing probabilistically what it should say. So it's not hard coding. For example, these are the exact stages for this practice area in this jurisdiction that every case lifecycle has. It's not hard coding that, hey, this is the base standard quality for motion practice in this jurisdiction for this practice area. So, what I think is that there has to be more sophistication around building in that hard legal logic and then figuring out what areas AI is good for and then what areas traditional software is really good at. And then what areas maybe we need to develop new tools for that we haven't considered yet. And also taking into account that every single firm and every single lawyer does things slightly differently, which was also a big shift recently where a lot of companies are trying to let firms build their own workflows. But again, it's still very much predicated on, just basic LLM calls. So where the direction that we're going is email first, having an agent that you can just speak to in plain English over email. And then on the back end, we have maybe 30 or 40 APIs that we take your plain language email, we translate it into JSON, and then we send it to those APIs to do something specific. So you say, hey, in this case, draft a motion for temporary restraining order, and this is why I need it. We take that, and then we have an 8 or 9 step workflow that produces a document which is maybe 70 to 80% litigation ready based off of your firm's templates and your motion practice and all of the case context. And then we send that back to you with the validated research. So we're very much trying to build that agentic associate that you can collaborate with of the future. And a lot of people are making that claim, but if it's just a chatbot, then I struggle to see what the difference is between that and Chat GPT, for example.
Yeah, I wanted to pinpoint a little bit on the part about you use email as your interface with the client and your platform. And that kind of goes hand in hand with what I'm seeing when you want to talk about a successful adoption. Usually, when you're pulling users or clients away from what they're used to, either it has to be really good and it completely revolutionizes the way they're doing things with zero effort from their side, which is usually not the case. So, how did you? Because I think that in the beginning you weren't email focused. If you could
Yeah.
talk a little bit more about that, how did that come to be?
So Jerks AI really popped in my head as a front end interface. When I very first had the idea, I had the idea of a docket that was enriched with a lot of information that could do some processing for you right there on the docket because I'm not sure if you've ever seen Pacer, the United States federal filing. It's horrible. It's, the user interface is confusing. It's difficult to see what's going on unless you've been trained on it. It's just, it's just a very difficult hurdle for a lot of people to overcome. So we invested a lot in building a really nice, really clean, very easy to use, self-explanatory front end interface. And I still stand by it. I think it's great. Right now, we even have public case pages, so people don't even need an account if they want to see an update on the case. With all of the enriched information, they can go on and take a look on it. And we're optimizing it for mobile. But what we realized was people we speak to attorneys, they would love the platform, they would sign up, they'd pay for it, and then they would never log in. And we were bewildered. We didn't understand, why would somebody, acknowledge that this could be so powerful for their practice and even be willing to pay for it but then not use it. So what we started doing is sending some of the outputs to email just so that users could keep track of the outputs more easily. So if you went on the platform and drafted a document, we'd send you the same document attached in your email address, for example. And then we started adding some automated stuff. So we figured, users are not logging in. What if we had the platform be more proactive and kind of nudge them? So we added it doing research. So it'll just go out, look at your case facts, and say, hey, I did some research for you, and send you a very long, in-depth research brief that's been validated in post-process for validated citations. And eventually what we started to realize is then we added docket updates. So whenever something happened to the docket, we'd send you an email for that. Eventually we started to realize is that users would come back and say, oh, I really love the emails. I really like that whenever anything happens on my case, or the agent will even just proactively go and do things like write a response brief. So then that got us thinking, wow, a lot of our users are just interacting with the platform by reading the emails and getting Word documents out of the emails. So then we thought, well, what if they could reply to the emails? Or what if they could initiate something by sending an email? So when we had that idea, it was kind of a eureka moment for us, because then we realized, oh wow, what if they could just talk to it like a colleague? What if they, instead of buying a platform and then upskilling and having to learn and having to go through the user interface, as easy as we've tried to make it, what if they could just continue how they've always been working, and the same emails that they sent to the paralegal or to an associate, they just send it to us. They send it to an agent address, and it does the same thing that they would expect. So we had to set up quite a few things on the back end, but essentially we have an intake layer that gets the email, processes it, cleans it, figures out what the attorney is trying to say. Then we analyze it on another layer, translate it into an API call. There's a lot of things that have to happen because we have to check the databases, and we have to check case information, and we have to, there's a lot of things that have to happen, but then we send it to the appropriate workflow. And then at the end of the pipeline, the user gets a response. So it could be something as simple as, in my case, Klein versus Velenos Capital, please draft correspondence for my client. And then, within 3 to 5 minutes, you have a draft email that has come back to you. Or it could be something more complicated, like I need precedents in the Northern District of Texas about RICO cases where all of the assets are in one jurisdiction. Then it will go out and send you the validated research as a response. So to your point earlier, it is very much about trying to integrate where attorneys work, because attorneys are busy people. They have a lot of stuff that's going on, and they don't necessarily have the time to upskill on every platform that is trying to sell them. So making it as seamless as possible, ideally without them having to change anything about the way that they work, we think is the next step forward.
What are some of the other reasons for blockers for adoption that you've seen? Let's say you address this big one. What are, if you could prioritize, what is the next big adoption blocker?
Part of it is just skepticism about AI, and some of that is definitely warranted because if people are just pushing, every day you're just getting somebody trying to push you chatbot as a solution, and you figured out already that chatbots are not the solution because they make stuff up, they make citations up, and you don't feel comfortable relying on it, then that's justifiable. Additionally, a lot of attorneys just don't want a tool automating or augmenting some of the stuff that they do manually,
Mhm.
because they take pride in their work. And that's understandable. If your job as an attorney, your work product is to produce legal documentation, um, the way I think about it is a lot of attorneys are not entrepreneurs. They're more like artisans or craftsmen. So if I were to go to someone who prides themselves on designing beautiful dresses, and I said, "Hey, look, there's this great AI that can more efficiently make dresses in your exact fashion, and you can make 300% more dresses in the same amount of time," they'll feel insulted because the whole point is that they are making the dresses. So a lot of attorneys look at their work product in that fashion. Now, I think that's definitely going to change, especially with the cohort that are being raised on ChatGPT and using ChatGPT all throughout law school, possibly using other tools. But that's another hurdle for adoption. Um, there are some attorneys that are just technophobic. There's a lot of law firms that still print out emails and even have paralegals, they'll dictate to them and they'll handwrite stuff. So that's a burden. But I think that cadre is starting to kind of die out and retire. So some of it I think is very warranted skepticism. I also think the industry is just very saturated. There's just way too many options. It's overwhelming, and so many of the options are generalist options. We try to make very specific tools for specific practice areas in specific jurisdictions, so people know, hey, look, this is the tool that is specifically for what I'm doing. Um, so a mix of it is just warranted skepticism, and a mix of it is just old legal procedures that are going to take time to change, I think.
You described it really nicely with the craftsmanship analogy. I think that really hits the point. Even with the craftsman, whatever a craftsman does in the process of crafting, some things, even a craftsman doesn't need his full capabilities to be able to do those things. So when a craftsman is onboarding a new junior craftsman, an apprentice, they are already outsourcing those mini parts of the process throughout the collaboration, throughout the journey of the apprentice. And now if we think of an AI as your apprentice, couldn't we draw some parallels from that analogy that yes, even in a highly intellectual and process that a lawyer does, in, let's say that your work product is a contract. Even in that process of a contract, you need all your years of experience, you need all your situational awareness, you need all your brain cells. But even not for every single part of that process, you need that. So when you start thinking from that perspective, to us, because we have been building those systems in that methodical way, it makes sense. I see a lot of friction when I try to explain to legal professionals who aren't used to that type of thinking. How big of a friction do you see there, and how do you go about that? Trying to explain that methodical, granulating of a process.
I think one of the hurdles of communication there is that lawyers are comparing the systems that they're considering onboarding not to a paralegal, but more to their end product. So they're looking at, oh wow, this output would never fly. Um, this doesn't look right. It should actually be like this. They're not looking at it as, hey, this is, someone that is actually has a job application and wants to come through the door, but will need a little bit of training. And if we can shift that, I think they'll be more forgiving. But there has to be some kind of demonstrated ability for the system to improve and adapt around their training. So if you have a paralegal that you onboard and after 6 months they're still doing the same thing as the first day they came on the door, you're gonna fire them. This person is just not a good fit for your organization. So one of the ways that we try to accommodate our users is we let them have firm level and then even user level motion practice and motion templates. So we will take examples of things that they filed in court and then integrate them into our system so that every time they file a motion to dismiss, it's in that particular style. And then that way, over time, the system becomes more like something that has learned and grown and become part of the organization. You're right that everybody has to delegate some things, but it also there's just an adoption window, right? Certain people will always be early adopters, and other people will be laggards. And there will always be some people that just take pride in every part of the process. Till today, there's still Amish artisans and craftsmen, and people highly value certain things that are just done the old way from top and bottom. So I think that those people will still exist in legal, but to your point, I think people will start to realize, hey, maybe I only really need to get certain things about my style of motion practice right the first time, and then I can automate it so I can focus on what actually matters, which is, the more sophisticated legal reasoning, the more in-depth research, and, the more controversial or less litigated or adjudicated areas of the law.
I do understand very much what you're talking about, and this is exactly the approach that I advocate for, because AI is not one of those types of technology that you can buy off the shelf. You do have to invest a little bit into it. So, for example, you just explained in your platform, you do have to kind of maintain some information that is highly specific to your firm and your type of work. Otherwise, AI is going to generalize. It won't know. And you and I both know that you cannot train ChatGPT, right? And we cannot really train an LLM model that we don't have the code to, that we don't have the weights to, right? So systems like yours, they don't really train the model. However, you're building your own contextual layer that is able to, every time that the model is called, pass a little bit of the DNA of the client to the model. So the model knows a little bit more, but the model, we can't train the model. And that's the misconception that I also see a lot. And I see also, I'm talking about this because I see that it's being taken advantage of. It's being explained like, the model is going to keep on retraining and it's going to keep on doing better without you having to do anything. It's not actually the case,
Yeah.
because you're going to be putting more and more information into the platform. That's why the model will know. So nothing comes, there is no reward in life without any kind of, without any effort, right? So if I want to play a difficult customer with you and we're now in a sales call and you try to sell me, right? Then I would be asking, and that's like literally, I'm seeing this on a lot of social media. That's why I'm saying this.
Mhm.
So here you're telling me that you have built a solution that is going to be able to kind of help me. But on the other hand, still I have to invest so much into it. I just want an AI that just kind of integrates with everything that I have, right? Because I have scattered docs all over. I don't want to be migrating none of this, and I don't want to be keep on spending my days thinking, how do I polish the instructions, right? Like, so why doesn't it just work out of the box for me?
Yeah, that's a really good question. And what I would say is there's a certain level of working out of the box that is possible. The question is, would you actually accept the work product that comes out of that? And the answer is most likely no, because you have a very particular way that you like to do things. So we try to make that upfront investment as absolutely minimal as possible. There's been a lot of talk about getting firms to reorganize their internal data and get it structured, and we're not going to require anybody to do that. We already have a very structured and robust and sophisticated data structure on our side. We just need you to fill in the blanks when you want to at your own leisure. So let's say you add a case, that's it. You sign up for the platform, you add a case, you never have to log in, you don't have to actually do anything else. It will send you research about the case, it'll let you know when there's docket updates, and it'll draft documents. But let's say you get a draft response brief from the platform and you look at it and you're like, oh my gosh, this is not the right style. Should actually look like this, should actually look like that. Very easy. You don't have to give us any instructions. You don't have to worry about crafting a very long prompt. Just find in your own organized or disorganized set of documents that you have internally, find any previous example of something that you filed in court. If it's a motion to dismiss, find some motion to dismiss that you filed and just send it to us. That's it. We will rerun it with your style, and then you'll get one that's according to your style.
So you're
And
basically
of
kind of
course,
also, sorry, go ahead. Yeah.
some lawyers are more proactive, so they'll go through and they have everything structured, and they'll go through and load the whole firm style in, and that's great because then it will work just as expected. But if they want to do it on a case by case basis, that's fine. And if they don't even want to use any of the drafting capability, maybe they just like the validated research or the hallucination detection or the other stuff, that's fine as well. Every lawyer works differently, and some of them maybe don't want paralegals doing as much drafting, and so they might not want AI doing as much drafting. So we really try to make it, you know, as similar to interacting with a human as possible. If you have a paralegal that is onboarding, they're not going to be writing in your style until they see examples of it. So it's the same logic.
Yeah. Ooh, ooh. You give me a lot to think about. That's why I'm yeah, trying to figure out what is then the best thing to say out of everything that I have possible. And okay, so how much friction do you have when you're onboarding a new client? Because I imagine that I don't know how to say this in non-business terms. Yeah, the churn is big if you don't really invest any time in, let's say, if I have the platform for 8 months, if I don't invest any time into it, I mean, it's not going to do any better. And I'm going to be like, well, I didn't take time to kind of get my documents in order in all that month so far, so I'm not going to do it anymore. And then how do you kind of handle that education part, that first friction adoption touch point when you, yeah, introduce them to the new platform?
So it really is a case by case basis. Some attorneys are very, very ornery and defensive, and they're like, no, the writing style is totally wrong. Why is it like this? And then other ones are just happy to have something that is easy to use, that is doing a good enough job out of the gate. So we really just have to do it on a case by case basis. And sometimes that involves, almost no education. So we just have to basically take the brunt of, hey, look, we need this template from you. Hey, look, we need this document from you. We need this. And they just send it to us and we'll manually populate it for them. Others are just very proactive and will go in and do it on their own. So it really just depends. It's on a case by case basis. But what we found is that our churn is pretty good in terms of people not churning out because of the fact that even the attorneys that are not proactively investing in the platform, there's certain things that work really well just out of the box, right? So research works really well out of the box. Validating documents, validating sites works really well out of the box. Docket updates works really well out of the box. So the part that does the drafting, even if that would normally require some more fine tuning, if they never do it, there's enough other meat there to where they kind of become reliant on getting these updates and getting their documents being pulled, especially with Pacer, because Pacer is really horrible. So having something that is proactively handling that Pacer layer for you and doing a lot of enrichment in the context of your case files, people find really valuable. And then, of course, for the motion practice component, there should be some investment there. But as a non-lawyer speaking, I think the first drafts that come out of the box are okay. I think they're pretty decent. Obviously, they're not how any one particular attorney wants them to look. Besides our chief legal officer that works on all that stuff, doing legal engineering in the back. So the approach of the user not having to lift a finger um, makes it a lot easier for them to justify when they don't invest in a platform because they
And
continue to get they get returns out of it even without necessarily making much more of an investment.
talking about a little bit the pains and the differences between ChatGPT and specialized legal tools. In our previous conversation, we were also discussing and touching upon what does it take to be able to expand in multiple jurisdictions while still maintaining the quality of the tool, right? So could you talk a little bit more about this and how you're handling it? What is the current state? What's the expansion plans?
Yeah, definitely. So expanding to different jurisdictions is a lift, to say the least. It requires quite a bit of work. The reason being is that, ChatGPT is just a generalist model. It's not even constricted just to legal information. So it can give you relatively decent advice about a lot of different jurisdictions, but it doesn't have years of litigator experience in any particular jurisdiction to tell you, hey, look, this is how it typically goes, or these are the various stages. Now, if you are a litigator and you already know these details, you can kind of you can kind of extract some of this information. But for it to be built in a tool that's ready out of the gate, and you don't have to update every conversation every time with this huge, lessons learned from you going back and forth with the AI, while also having accuracy, and then also having it work with the actual filing systems and documents of those particular jurisdictions, that's just totally out of the scope of what ChatGPT is capable of. So we started out in federal. Federal is one of the most organized, unfortunately, and one of the most sophisticated. Some states have some slightly better stuff, but we directly interact with court listener with Pacer, so that we can get you those documents and those dockets updated real time. So there is a level of actual interaction with the real world that is happening there. And that interaction is happening on a layer of hard coded legal logic that we've built in. So when we pull the docket, we understand what filings are at pretrial stage. We understand what filings are at trial stage, what are at discovery stage, what are at the stage of a verdict or post verdict appeal. And that's because we have attorneys at Jurist AI. So we've built that logic in, even though it's not available from the court directly. And all of this happens in a matter of seconds. So you get a new filing or the court docket is updated. You might not know typically for 3-4 days. Here with us, you'll get an update. Hey, look, your case has now moved into the trial stage because your adversary filed this. Hey, I've drafted this response brief for you. I've already done research. I've already read all of their arguments. So those are just things that ChatGPTs cannot do and will not be able to do, I don't think, ever, because it's not designed to do that. So as we move into other jurisdictions, we have to, from the ground up, conduct a gap analysis of, hey, look, this is how it works for employment law in federal, which is something that we do. But for California divorce, what's different between how a lawyer in federal employment law conducts a case versus how a lawyer doing a contested divorce in California conducts their cases? So we have to figure out that whole gap analysis and then re-architect the parts of the platform that are different. An obvious example is just all of the motion practice has to be different every single time. So if you go on our federal criminal tool and then you go and do patent litigation on our federal civil tool, all of the motion practice is different. The stages of litigations are different. The recommended motion types are different. The pre-built in motions are different. And where it's going to pull the research from is going to be different. So we are planning to move into state early next year, Q1, Q2. We're conducting a little bit of market analysis just to kind of see what jurisdictions and practice areas are going to be most ripe or prime for this kind of a tool. But that really is the motive we built in, is that we are hard coding that specific legal logic for that specific practice area in that specific jurisdiction out of the box. And you, as a lawyer, now the lift for you is a lot smaller. Instead of it being, oh, wow, I really have to go and build something from scratch, it's more so, hey, look, this is kind of default best practice, but why don't you send us how you guys do it at your firm? And then we can make that 10-15% shift so that now it really is like a colleague that has already been practicing in your area that is coming on board and you can collaborate with them.
So why don't you just use RAG? That concludes our conversation. No,
If only it were so easy. If only it were
yeah.
so easy, we definitely would.
No, but if anybody is wondering what's the difference between ChatGPT and why can't ChatGPT really do it fully perfectly, why do I need a specialized tool? I think that just for the past 2 minutes, they just need to listen to the past 2 minutes. This is exactly what's needed to get the accuracy on a level that the real legal world accepts as a minimum entry bar.
Exactly.
Yeah, but I do think that is a very good point to end on today's conversation. Thank you so much, Ali, for this. And hopefully we're going to be able to do this in the future as well. I'm going to be keeping an eye on successes of Jurist AI.
Thank you so much for inviting me, Roke. This was a really enriching conversation. I hope other people get as much out of it as I did.
Yeah, thank you so much, Ali. Thanks for staying till the end. Quick lessons. Don't use AI for citations. Validate them yourself. Predictable and reliable workflows over chatbots. And your attorneys will use AI if you don't introduce a new platform for them. If you enjoyed this conversation, follow along. There's more coming in the next weeks. See you in the next one.